Those who are going to present their cases today about timing. Each of you will have 20 minutes. When 15 minutes has passed, an amber light will come on the front of the podium, and that means that you have 5 minutes left. At the conclusion of the full 20 minutes, you must cease your argument. You will see that there is also a clock up here on the bench to help you keep your own time. Madam Clerk, would you call the first case, please?
S12A 1720, Carlos Bartram et al. Versus City of Atlanta. Steve Wolfe for appellant, Larry Cheshin for appellee.
Mr. Wolfe, you may proceed.
Good morning, Your Honors. I'll argue for 15 minutes now, and I'll hold 5 for rebuttal. My name is Stephen Wolfe. I'm from Buckley & Klein here in Atlanta. We represent the appellants in this case, Lieutenants Carlos Bartram, William Edwards, Royce Turner, and Derek Dabney of the City of Atlanta Fire Department. The trial court's final order below deprived our clients of a property interest in their ranks as lieutenants in the fire department. It did this by ordering that they be summarily demoted and that they be disqualified from participation in the new round of testing unless they can score within 24 points of their original 2010 score. The threshold question on a due process issue is whether there is a legitimate claim of entitlement or legitimate expectation in whatever it is that the government is trying to take away. In this case, there was. 3 weeks before this case was filed in court and 4 weeks before any judicial action was taken, this testing process was completed. A final list had been certified in ranked order. It had been distributed to all members of the fire department, and all members of the fire department received a memo, which is of record, Plaintiff's Exhibit 7 at trial, stating the following members are promoted and listing them by name in order. This occurred 3 weeks before the case was filed in court, 4 weeks before the preliminary injunction, which the appellees refer to in their brief. This is significant because once this memo is issued, all that remains is the purely ministerial act of promotions which have already been made taking effect on the predetermined date which was stated in the official memorandum. When a member of the fire department receives a memo from the fire chief stating you are promoted to lieutenant, this creates in that member a legitimate expectation that he is promoted to lieutenant.
What's your best case for that?
The best case for that, Your Honor, is
getting a memo without any official personnel action or anything else without an official personnel action creates an actual property interest.
Sir, Your Honor, there actually is a case directly on point for this, although it's persuasive authority. It's the Otero versus Colligan case. This is not cited in the brief, but I'll give the court the pinpoint cite now. It's out of the District Court of Connecticut, 2006 Westlaw 1438711. In that case,
let me ask that you please submit a supplemental brief on that case, and I'll give you 5 days to do that and 5 days for your opposing counsel to respond.
Certainly, Your Honor. On the broader question of when does the property interest attach, and this may go more generally to Justice Namias' question, the source of the due process protection is in the due process clause of the Constitution. But the question whether and when does a property interest attach is answered by looking at the ordinances, the personnel procedures of the entity. And here, there's no question the City of Atlanta has a merit system. There's no question that it applies to our clients. The provisions of the merit system which are on point are of record. They're among the trial exhibits. They are City Code provisions 114-229 through 114-250. And
Mr. Wolfe, could you tell, when they talk about the retesting in this case, and you talk about like a scale of 24 points, you mentioned 24 points. What is the actual scale? Is it like a test that's 1 to 100? Is that what it is?
Yes, Your Honor. It's multiple choice, 100 questions, and it's scored 1 to 100. And what the trial court held with respect to that is that solely as to the individuals who scored an 84 or above on the original test, which includes all 4 of our clients, those individuals have to score within 24 points of their original score, or they're disqualified from further participation in the new round of promotions, even if their score would otherwise have been passing. And we contend that that is a deprivation of their due process rights. And
Can I ask you this, have y'all tried to mediate this case?
Your Honor, we have not tried mediation. We've had informal discussions between the parties.
Well, the city seems to say that they would extend that 24-point variance to every test taker on the retake.
I did note that footnote in the appellee's brief. I wasn't certain whether that was some sort of stipulation or whether it was simply an acknowledgement that there's some unfairness in that and that it indeed should be applied to everyone.
Is that not would that position be unsatisfactory to your clients?
Your Honor, I'd have to discuss it with them, but my initial impression is that would be satisfactory. Our core contention with the problems with this injunction, paragraph 6 and paragraph 10, those paragraphs that apply specifically to the people who are being individually targeted. Our core contention is the singling out, the individual adjudication of their rights separate and apart from generalized relief on behalf of a class against the city in a case that was pled only against the city and only for a retest. And so,
well, if appellees take that position and your clients take that position, sounds like y'all could work this out.
as to that requirement, I think that we could. That doesn't cure the other problem with the injunction, which is paragraph 10, the paragraph that says those who score 90 or above are going to be summarily demoted. That they've made no suggestion in their briefs that they're willing to move on that. And if that's the issue that's remaining, that's still a sufficient deprivation of property that warrants reversal of the order.
ADR sometimes works in very mysterious ways, and if you get your nose under the tent, if you're a camel, sometimes you can get the whole thing worked out.
We're a fan of mediation, Your Honor. If it's, we'd be willing to pursue it, but it hasn't been agreed upon, it hasn't been discussed, and in the absence of that, we do seek a ruling that this injunction is void and needs to be struck.
To follow up on Justice Hans, if you could talk about standing and then overbreadth.
Certainly.
Let me tell you, can I just ask first, on your point about a property interest, what was your client's rank, official rank, at the time the lawsuit was filed and the injunction was entered?
They were sergeants at that time with the memo in hand saying you're promoted.
With a piece of paper that said you're promoted, but no actual action changing their rank.
I would challenge that characterization of it just slightly. They had the memo saying you are promoted, and that memo is delivered in the context of all of the city's merit system protections, which say that once you're on a list, you can't be removed from it except for cause, and the due process has to be attendant to that. So in other words, if the city had determined... Except for cause, for example, a lawsuit that determines that you cheated. Wouldn't that be cause? Your Honor, if they had been served with process and named as defendants and given notice and an opportunity to be heard, it would. It would. It's not an inviolable right. The government can take away property. It just can't do it without due process of law. And the way that due process of law is satisfied in this case, the only way it can be satisfied is by naming them as parties, serving them with process, and bringing them into the case. Absent that, the court does not have personal jurisdiction over them. It cannot enter a judgment against them, and the judgment is void and can be challenged at any time. And to address the question about standing, there's two reasons why we have standing. One is statutory, and the other is a creature of case law. There are two separate Georgia Code provisions, which are more or less similar. These are 9-12-16 and 9-11-60A. And these two provisions state that a judgment that is void on its face can be challenged by any person in any court at any time. And this court's decision in Murphy versus Murphy, it was a divorce case looking at 9-11-60A. The court read the language void on its face in that statute to mean void for lack of personal jurisdiction or lack of subject matter jurisdiction. So that's the first element of standing here, that the court lacked personal jurisdiction over them. The judgment, as it specifically pertains to them, those two paragraphs of the injunction which we challenge, It's void from the get-go. We can challenge it here or at any time. The second basis for standing is the case law. And the best case on point for this, it's a Court of Appeals decision, but it's well-reasoned. It's BEA Systems against Web Methods. We've cited it in our briefing. This was a case where a officer of a company had departed, gone to a competitor, taken some trade secrets with him, and the plaintiff in the case, his former company, sought an injunction. It sought the injunction in its pleadings against the individual, but the trial court enjoined both the individual and his new employer. The new employer was not a party to the case. And the Court of Appeals reversed and said that by entering that injunction against this corporation, which was not a party to the case, the court lacked jurisdiction over them, therefore violated their due process rights, and reversed the case. So two separate bases for standing, one statutory, one based in the case law. The basis for standing is related to the underlying problem with the injunction. They're interrelated. An injunction that is entered against a non-party makes that party non-party a party with standing to appeal. That's the holding in BEA Systems, and that has to be the law. That has to be the law. Personal jurisdiction.
When were they put on notice that they were going to be affected by this particular judgment?
Your Honor, they were never put on notice. The only notice that is sufficient to satisfy due process when it's a state trial court that's taking away the liberty or property is service of process, and that never occurred in this case. They were never named as parties. They were never served with process. The appellees in their briefing have made much of the fact that the appellants in this case were always sort of the subject matter of the cheating allegations. They were involved in the transaction, and that this somehow placed them on notice that they should have affirmatively intervened in the case. But that's incorrect. Those duties flow entirely in the opposite direction. It's the burden of the parties to a lawsuit or the trial court overseeing it to recognize when relief requested is going to have a substantial impact on a non-party. And 9/11/19 of the Civil Practice Act makes joinder of such a non-party mandatory. And there's a critical difference between 9/11/19, which provides for mandatory joinder of a non-party that's going to be affected by the relief, and 9/11/24, which provides a non-party to be affected by relief with the option to intercede. It's mandatory when a non-party is going to be affected that they be joined if it's recognized. It's not the burden of a person knowing that a lawsuit has been filed against someone else to peruse the docket of his local courthouse, determine whether this case that's been filed against his employer might somehow result in individualized relief against him, and then hire a lawyer on his firefighter's salary and intervene in the case. That's not the law. And in this case, the first request for any sort of individual relief against our clients, the first time that this case became about anything other than a redo of the 2010 examination was after the verdict, after 2 years of litigation. The first request for individualized relief against our clients was made on Tuesday, March 6th, in the form of a brief by the appellees. It was not served. The case caption was not amended to bring our clients in as parties. That brief was filed on a Tuesday. The court held its hearing on a Wednesday, the very next day, and our clients were not present and not represented. And it entered the final order on a Friday. 3 days.
You said that before that, the only litigation was about a redo of the test, but I understood you saying that even if you struck the kind of provision about the 24 points or extended it to everyone, that wouldn't be sufficient because your position is your clients are already promoted, so a redo of a test would not have, I mean, you couldn't really have a redo of the test because the test results have already been certified.
Your Honor, we see those as two different issues. And we don't challenge the general part of the injunction that says there should be a retest. What we challenge is—
Are there any positions left if you do a retest, are there any positions left for people to be promoted to, or do your clients already fill all those positions?
Your Honor, my understanding is that the number of vacancies actually exceeds the number of candidates who would take the retest. So everyone will be promoted. The harm of the demotion, the specific reason why this deprives them of due process, is first that being demoted from lieutenant to sergeant is going to reduce their compensation. And second, the city code requires that in order to be eligible for promotion to the next rank, which is captain, they must have served 2 years continuously in the position of lieutenant. So if this injunction becomes effective and they are demoted, they will have a break in their time and rank as lieutenant. And that can't be cured. Their careers will be forever set back for 2 years, even if they take the retest, pass with flying colors, and are promoted in the first wave. Now, I've got about 30 seconds left before I save my time. I want to just suggest the bigger picture of this case. The problem with affirming this ruling is what it does for the next case. All the time, injunctive relief is sought against an employer, most commonly in a case about a covenant not to compete. The plaintiff is a corporation. One of its officers leaves. It takes some client information with him, goes to a competitor, and the plaintiff seeks an injunction against the president of the departing officer and the new corporation that says, stop competing against us. There's nothing wrong with this. That happens all the time. Affirming this ruling will mean that in the next case, after that happens and after there's been a trial on the merits, the trial court sitting in equity can go through the witness list, go through the defendant's employee roster and say, the facts adduced at trial convince me that the following 3 members of middle management are particularly culpable for this harm. And so I order that this one be demoted, this one be docked pay for 2 years and use that to pay the judgment as particular punishment for his individual action, even though he was never served with process, never brought into the case as a party. And that point is particularly significant because the upshot of the appellee's argument about the effect of the preliminary injunction is that it essentially makes these people at-will employees. Almost every employee of Georgia is an at-will employee. There would be nothing to prevent this from being extended to that next case. I'll hold the remainder of my time. Thank you.
Thank you, counsel. Mr. Chesson?
Thank you, Your Honor. We represent the individuals who brought this case. The case is styled here as the